Well, thank you for that introduction, and we're very pleased to be here, obviously, to talk to you. Can I just introduce the topic by dealing with a couple of housekeeping issues? We're more than happy for you to interrupt us and ask questions along the way if there's something that concerns you or interests you, or you've got a contribution to make, and we would like it to be interactive if it can be. So please feel free to put your hand up, and we're more than happy to take questions along the way. Second, I just want to talk a little about the heading corporate mortality, because in some respects it reflects a lot about our history when you deal with corporate restructuring. And if you think about the history of Australia's corporate restructuring, it goes back to our history as a country. As a country, convicts were sent to Australia. Why were some of those convicts sent to Australia? They were sent to debtors' prison, and from debtors' prison they were sent here as convicts. That is, people who did not pay their debts were locked up and were sent out here because it was regarded as a crime. And that is the juridical history of corporate restructuring in Australia. That is, we have a criminal background to it. And that's why with corporate collapses we have public examinations. We have referrals to the regulator to prosecute breaches of the Corporations Act. The history of corporate restructuring is all about our history as a nation. Whereas the US, by contrast, is quite different. The US is all about rehabilitation. The US is all about entrepreneurship, taking risk. If you take risk in an economy, there will be failure. Just because there's failure doesn't mean that there's wrongdoing, and therefore the US approach to restructuring is quite different from the Australian and UK approach. The American approach is all about rehabilitation. And in terms of where the market is now at in Australia, we have moved from our history of punishing corporate failure to focusing away from this concept of mortality to saving corporations, saving them to save iconic entities, saving them to preserve jobs, saving them to avoid dislocation, saving them to in the best interest of economies. And when we get to Arrium, we'll talk about the economic impact, broad and narrow economic impact of Arrium. So that, you know, from our perspective, we think that it's when you involve yourself in this area of the law, it's an area of law that lends itself to incredible creativity, to incredible opportunity, and to actually doing something very decent. And if you actually talk to all the major players in this space across the country, you'll find that their motivations are all very similar. That is, most of them are here not to undertake corporate bodies that need to be buried and cremated. What they're about is saving jobs, saving businesses, and adding to the betterment of the economy. And certainly the Arrium story is a remarkable story, which we'll talk you through, and I'll let Susanna kick off with that.
So this first slide is not Phoenix rising from the ashes, but actually a photograph from the blast furnace in Newcastle, which I got to, one of the joys of being a partner is you get to go on excursions occasionally, and I got to go to the Newcastle blast furnace of Arrium in the process of this restructuring that Leon and I were involved in. We thought we'd take you through the Arrium collapse basically as a way of giving you some practical stories about how the various different provisions of the Corporations Act that deal with corporate insolvency apply in practice, and the flexibility and, as Leon says, the creativity that you get to enjoy when you're practicing in this area, which has been a real eye-opener for me. I have to say I learned almost everything I know about corporate insolvency from the feet of the guru himself. So it was a real joy to work on this restructuring, which we did. So let's start off with some background to Arrium, and I don't know how much of you you know about it. Oh, that was successful. There we go. Arrium was an Australian-based mining and minerals company. It was spun out of BHP Billiton, and also a series of mergers that happened with Smorgon, and it was some of the products that you'll know or recognise, household names. It produces cyclone fencing that you see around, paddocks and tennis courts and all of that sort of stuff. They also produce, interestingly, for the Australian construction industry, what are known as I-beams and J-beams, which again, you don't necessarily learn about at law school, but turn to be the main structural steel that's used in all of our construction. And without Arrium, Australian construction would be required to import structural steel in anything other than particular, already agreed lengths. So every time you needed anything bespoke to build a building, you get it from Arrium. They build bespoke lengths of structural steel. The third thing that they produced, which was known as the jewel in the Arrium crown, it was mining consumables. And when I heard about the jewel in the Arrium crown when I went to visit the blast furnace factory in Newcastle, I was expecting jewels, but instead they're kind of dull, large balls of metal that are used to crush up minerals that produce copper, tin, all of that sort of mining industry. So the jewel was known as the Mollycop Mining Consumables business, and it basically, Arrium operates in all the states and territories of Australia. At the time of its collapse, it had pretty close to 10,000 employees, and so to give you, a practical example from today, we've heard about Jamie's Italian collapse, which is all over the news. That's only got 1,300 employees, so this is a huge collapse from the perspective of employees of the group. And structurally, significantly important to Australian industry, and also regionally important. Just make sure I'm pressing the right buttons here. I mean, one of the major sites of Arrium is mining and minerals that's coming out of South Australia. It was a significant factor in the South Australian state election. In 2016, there was significant promises of funding to try and prop up Arrium by both the federal government and the state, both political parties, and I think Nick Xenophon also had a role in that. I don't know if you have anything to say about that, Leon?
Yeah. First of all, whenever you get involved in a large corporate collapse, whether it's Arrium, whether it's an airline, whether it's a nickel producer, whatever it is, the starting point practically is to identify the key stakeholders. So who are the key stakeholders in the collapse of Arrium? And let me just run through them. I won't ask you to expand upon who they might be, but let me just run through them. The first is government. Why government? Steel infrastructure. Steel infrastructure. If Arrium closes and it's gone, all of our rail infrastructure and building infrastructure has to be imported probably from China. In other words, if this shuts down, there's going to be a huge problem for the government and for the country. A second major stakeholder is the Commonwealth Government Department of Employment and Workplace Relations, Zwier. Why Zwier? Because when it failed, there was insufficient money to pay the employees their entitlements. And we have a guarantee scheme for employees called FEG, Fair Employment Guarantee? Yeah, something. Fair Entitlements Guarantee. Anyway, FEG. We all call it FEG. And therefore, there's going to be a huge claim on FEG, so the Commonwealth has another interest. Then you've got a political interest, which is, if it's the third largest town in South Australia, how is the government going to deal with it? What is the opposition going to deal with it? How is this going to play out with an impending election? And
this is the only significant employer in the town. All of the property prices and all of that sort of stuff are dependent on this employer continuing.
And then go down the line and work out there's a state government. The state's got, this was going to impact the economy of South Australia by about 5% if it closed. 5% of the GDP of South Australia was at stake over Arrium. That's a huge amount. And also there was going to be a huge social dislocation moving all these people out of the township if you couldn't keep it running. So they're involved. Then you have a whole lot of Australian banks are involved. So they've got an interest in maximising their return. Then you have US note holders, they have their interest. Then you have a unionised workforce and you've got the unions involved. What do unions want? They want the payment of the employee entitlements and continuity of employment. Then you had a whole bunch of representatives of non-union employees who dislike the union reps but who are looking out for the non-union employees. Then you have your ordinary suppliers. And what you have to work out in any of these corporate collapses is, what does each stakeholder want and how am I going to deal with each stakeholder? And they're all going to lawyer up. Every one of these stakeholders will lawyer up, and bear in mind that each one of them has the capacity to destroy a plan to save an entity by exercising rights in a particular way, which means you have to do an enormous amount of strategic planning. You have to have a lot. Media is another aspect. You have to manage media. You have to understand government relations at a state level, at a Commonwealth level. You need to understand union politics. So it's a fascinating area for practitioners to get involved in, and with enormous scope to meet important people for all time. For all time. Many of you will know that we've acted for prime ministers, leaders of the opposition. Where does it come from? Corporate failure. Corporate failure. Generated connection to the future generation of leaders of the country, and that is how we built those connections, through doing good jobs and saving corporations. So stakeholder identification is a key aspect to understanding large-scale corporate problems.
And the reason Leon says it's important to work it out lies in basically the framework of Part 5.3 of the Act. Sorry to take you back to the Corporations Act, because it's much more fun to talk about the holistic approach to restructuring insolvency. But this is the part of the Act that says, in the event of an insolvency, the affairs of the insolvent company are to be managed in a particular way to maximise the chance of the company continuing business or continuing existence as long as possible. And if that's not possible, to make sure that you get a better return to your creditor pool than you could in basically an immediate winding up. And I understand that some of you have already looked at the various different types of corporate restructuring, from receivership, where you have people who have security over assets, through voluntary and involuntary winding up to voluntary administration, which is primarily what Lee and I will be talking about today. But when he says it's really important to identify who your creditors are, who your stakeholders are, it's specifically for these, to make sure that you're complying with the objects of the part, because this is where the power comes from as administrators. And just in terms of two of the other things that Leon has said, it's probably useful just by way of background is to understand what happened with the financing of Arrium. Arrium was financed by basically a group, a syndicate of banks. They included the 4 Australian trading banks, but also overseas note holders. And then there was some kind of last-minute finance that came in by what was called a vulture fund. I always like the name vulture funds. They're not hedge funds anymore, they're vulture funds. And they had come in with a kind of lifeline at the very end. But the promise that they were trying to extract from the company while it was still alive was that they would shaft all of their previous financiers, and the financiers in a collapse would have ended up with significantly less by way of cents in the dollar. And so that was the creditor group in terms of the financing structure that we were looking at. Just in terms of some of the numbers, there were over 30,000 customers of Arrium, so it's a huge business running all over Australia and in 12 different countries. There were thousands of trade creditors, so people who were providing, whether it's rolling stock, so to actually get minerals from Whyalla, basically, to blast furnaces. There's huge rail companies, there are significant electricity providers, water providers, all of these types of utilities. Some of the other creditors in terms of the state governments were people with an interest in long-term environmental liabilities. One of the difficulties, as you can appreciate, with a company like Arrium is it's a big polluter, and while it has money, it has obligations to remediate after it abandons a site or after it's finished doing particular things to look after the long-term environmental liabilities that exist in these particular types of industries. And you can see it with Arrium. You can also see it with another company that Leon's going to talk about, James Hardie, with asbestos, that while the company is solvent, that's all very good, but the moment the company is insolvent, your environmental liabilities effectively become a problem with the government to look after. And so that was one of the other factors that was playing in the creditor consideration at the time. So basically, following a fight between the Vulture Hedge Fund and the Australian Banking Syndicate, the directors basically formed the view that the company could no longer continue, and they voluntarily appointed administrators. They appointed administrators who were initially friendly to the director group, and you could appreciate there were, again, significant disagreements between the creditors as to who should be the administrator. Once, and again, those of you who've done this, apologies if I'm repeating material, but what happens is power and control of the company transfers from the directors to the voluntary administrators, who are a separate group of individuals who are appointed in this. The first time it was from Grant Thornton, and then they were replaced with people from Quartermentha. So 4 administrators were appointed, and they take control of the companies that are in administration and go forward. Now, to give you some idea of the complexity of the Arrium corporate group.
Okay, can I just stop there and give you an idea of the commercial background to what Susanna has just described? The company is fighting for its existence, and invariably in the death throes of a company, it will go to its lenders and seek support. It will seek accommodation. It will seek additional financial support, waiver of covenants, all sorts of things to survive. And very often we've seen in corporate collapses, kicking the can down the road. That is, you keep it alive for a period of time and then work out what you're going to do with it. The trouble with this particular corporate collapse, which made it unique in Australia's history, is that the board came along to the banking group and said, we've done a deal with this fund, Susanna's Vulture Fund, and take it or leave it. Take it or leave it. And if you don't take this deal, which was cut your debts as bankers by 50%, this company is going to collapse and you won't get more than 25 cents on the dollar. So we've done this deal with the Vulture Fund. You either take it or go forth and multiply. And that was really how it was put to the bankers. And bankers don't really react well to ultimatums. You don't want to give bankers ultimatums. And so that's the backdrop. And what the bankers wanted to do, the financier wanted to do, was to make sure that if it failed, the administrators would come from one of the bigger firms to manage such a complex and large group. And so what the directors did when the negotiations broke down was they selected a second-tier firm, which was their way of telling the bankers and financiers what they thought of them. And so by appointing a second-tier firm who clearly didn't have the size and depth and capability to manage the problem, you had chaos, uncontrolled pandemonium. And there had been a plan to appoint one firm of administrators, and they were not appointed, and this meant you had a free fall. The US guys call this a free fall insolvency. Free fall insolvencies happen in our marketplace by and large once every decade. Once every decade. Ansett Airlines, some of you won't have heard of, but it was the second airline to Qantas, free fall insolvency. PASI, free fall insolvency, Pasminco. HIH, free fall insolvency. That is an uncontrolled, unplanned event brought about by some trigger event that no one kind of foresaw, and bang, you're in insolvency without any planning. And so it requires a massive effort to get on top of the legal issues, to get on top of the financial issues. And again, we start off with stakeholder management. Every one of those stakeholders were going ballistic. Every one of them. They all brought in advisors, experts. The other thing too, of course, is that invariably small bankers and financiers blackmail. They blackmail.
Greenmail.
Sorry, well, greenmail. I'm just more extreme than you, Susanna. They greenmail. So what do I mean by that? The principle of corporate restructuring is pari passu. Everyone of an equal ranking shares equally from the assets of the company. That's the principle across the globe. That is the principle by which every country deals with an insufficient money to pay all the creditors 100 cents on the dollar. People of a like ranking, so if you're secured and a group is secured, you get treated one way, unsecured another way, priority creditors another way, but everyone's treated rateably. They get their fair share. But the greenmailers, who are very clever, will come along and they'll go to a lawyer and say, look, we're only owed 20 million and the debt here was 2.9 billion. We could blow up Molicop and cause irreparable damage to the group, doing, probably 500 million, $1 billion worth of damage to you as banks. Why don't you just pay us out? Give us 20 million bucks. What's 20 million bucks to you? You've got 2.9 billion in this. Pay us out. And the minute you succumb to that, you have to succumb to all. And I remember I got a letter from, I think it was Quinn Emanuel, with that kind of demand. Pay me $80 million. I wrote a one-word response to the letter of demand, which was brave. Brave. And then
then he went to court.
Yeah. It was one word. I said brave. I don't like to be too long-winded about these things. And we went to court and we had to stave off a further global collapse of Molicop. So by this stage, Molicop's all over the world.
You've got to explain. So there are two parts to Arrium. There's the Molicop, which is the beautiful mining balls, and they were not insolvent. They were not in administration. They were actually beautifully profitable, but they were part of a group of 94 companies with interconnected guarantees. So all of the companies would guarantee the debt of all of the other companies. And so if you have a head entity that falls over, usually all of the subsidiaries will fall over as well. But here we had a part of the business that was, fabulously profitable, and also secured in that people had lent money into Arrium and had taken security, contractual security over those companies and their assets. So the Australian banks hadn't taken security over the rest of the Arrium Group. They were basically unsecured, so they were in the same position as, you know, the mum and dad trading suppliers who had basically extended goods on credit and were expecting to be paid and hadn't been paid. Australian banks were in that position, but the Vulture Fund had a bit of security, as did Morgan Stanley over Molycop. And so what they were saying was, if you don't pay us out in relation to our Arrium debt, we'll tip this section in as well.
Which is worth 1.6 billion. It sold for 1.6 billion, but if it fails, it'll be worth.
You end up
$1
with a
billion.
fire sale, and so, you know.
Yeah, and so let me just say, lest you should think that we're too pristine about it. I mean, everyone rotates chairs on these things. And so what you invariably do is find some kind of balance. So you had the Molycop Group, very valuable underneath the Arrium Group, and that was an issue, a day one kind of issue, on top of every other issue that was bubbling along. And you know, again, I won't put this in the context of Arrium. I'll put this in the context of another major collapse. When Ansett collapsed, a number of people committed suicide when it closed. And that's because it affects people's lives. The thought that all of a sudden the job that you've had for X number of years is going to vanish, and the company you've worked for that you've dreamed about for a long time goes away. It's a huge human impact. And so you've got all of this playing out at the one time. It's an absolute pressure cooker when you have a kind of free-fall insolvency like this. And Susanna's described some of the legal structuring, but we actually had to go also to court to change the administrators very early on. Now, I just want to talk a little bit. I won't talk about the application itself. I want to talk about the strategy and the tactics. We went to the federal court as opposed to the Supreme Court. And many of you may, you know, both courts have jurisdiction to hear these Corporations Act matters. But there's a difference between the courts. The federal court tends to allocate a judge that stays with the matter all the way through, which for corporate collapses is absolutely critical. Otherwise, every time you appear before a judge, you have to continually bring the judge up to speed. Federal court would allocate a judge. Supreme Court does not allocate a judge. In the old days, the Supreme Court tended to keep one judge on the matter. Nowadays, they don't.
So just even understanding the corporate structure here, I mean, you've got 94 companies all interrelated. To have to explain that to a judge every time is going to take your first day of hearing before you even get to the question that you're asking them to give you advice on or to opine on. It's, you know, it's just a lot of documents that had to be read, and this is one of the reasons that the federal court was attractive, because we had a judge up to speed.
Now you will learn in university that you can't select your judge, but I tried to. I actually reached out to the court and said, I want one of two judges. And I named the judges because I needed a really good corporations judge. And the federal court doesn't have specialist list. And I knew that if we didn't get a good corporations judge, there could be carnage in Arrium. And I named the two judges. I think I said I wanted Middleton or Beach. And
you got neither.
I got neither. I wasn't happy. I was not happy. But I should say that Jenny Davies of the Federal Court in Melbourne was allocated to the matter, and she was absolutely brilliant. I can say this, that I think, well, I know, that she found the whole experience of being a judge really, really important to her, because the judges play an interactive role. And I recall that when Ken Hayne first went to the High Court, he did the first large corporate group that failed back in the day when he was a single judge. One of the things he lamented was not being involved in corporate collapses like the ones we're describing now, because he says the judges play an interactive role in finding a creative solution to the problem. So that whilst the texts and the Act describe limited powers and the way the Act will operate, the creativity is built into it, and Susanna will no doubt walk us to those creative provisions.
Well, this is the first provision I wanted to talk about, which Leon said was even worse than the corporate mortality title. And he said this is where I was going to lose you all, which is the joy of the initial creditors meeting. But having had explained, what we were dealing with, the legislation requires you to have your first meeting of creditors to decide the future of the company within 5 days of being appointed, which was insane if you think about what was going on here. So the first thing we did was try and solve the problem of, even to post the required notices under the Corporations Act to each of the individual creditors cost $500,000 on each occasion. So there are a series of things that the law requires you to send to creditors before you have the first meeting. We had to identify who they were. Like I say, there were tens of thousands of employees. There were 30,000 trade creditors, mums and dad suppliers. There were syndicates of banks, including people overseas. There were state governments. It was huge. So the first thing we do, and this is where Leon, says this is not particularly interesting, but I thought it was kind of cute, was we moved the hearing of the initial creditors meeting, and there's a provision in the Corporations Act which Leon can tell a story about, which is kind of the magic provision, and usually for corporate law it's a provision that basically says you can go to the court and the court can modify any part of the whole of Part 5.3 if it so thinks fit. And so that's section 447, and that's the section that we used in these circumstances to basically apply to move the first creditors meeting and to change the way that we dealt with creditors. You'll appreciate in a corporate insolvency, each individual is a creditor of a different company necessarily. You're a creditor of the company that you've been dealing with, and this was a business that had none of its business entities matched up to the corporate structure. The employees were employed by a company that had nothing to do with where they were working in Whyalla. The company that owned the assets in Whyalla was not a company that was based in Whyalla. They were all sort of mismatched within the corporate group. And so what we did was come up with a way of dealing with one combined creditors meeting rather than having 94 different meetings for each individual entity. And we only had to send one lot of notices out rather than $500,000 on each occasion. So I know that's not particularly scintillating, but that was the first kind of fun thing we did.
I thought it was one of the less interesting aspects of it, but I should say this.
It was the first thing I did. He was busy doing other stuff.
I should say this, that we did something which is counterintuitive in the profession, which is we went to the regulator, ASIC, and we engaged with ASIC to explain these kind of problems to them very early on, and really we negotiated a package with ASIC where the regulator was comfortable with us not complying with the law. Now, the section that Susanna talked about, section 447A, is a broad plenary power. The High Court has said so in Australasian Memory and Bryan. It is so broad you can do anything in terms of restructuring companies. And that's why this area I regard as so creative, because you can do whatever you need to do. In fact, the anecdote that Susanna was going to tell you is that many years ago I had the experience of converting law, L-O-R-E, into law, L-A-W. At a very hotly contested meeting with lots of lay creditors, that is not lawyers and professionals, there was a very big issue about the structure that I was putting up to the plan to restructure the company. Someone got up from the floor and said something like, that structure is illegal and it won't work. And I disagreed with them and I said, look, even if you're right that it's a bridge too far, there is a provision in the Act, and I didn't refer to section 447A because lay people, it would mean nothing to them. I said, there's a magical provision that a court could use to fix the problem. And if the court uses the magical provision, we won't have a problem. And I said, and so what, if you're really worried about it, we'll go to court and we'll invoke the magical provision. Anyway, we went before Justice Warren, our former Chief Justice, and I ran the argument, and she referred to that meeting and she said, the lawyer for the administrators talked about the magical provision, and that's clearly a reference to section 447A. And she then goes on to say, and talks about what we want to do, and she says, and it is a magical provision, and it will fix this kind of problem. So I always say I've managed to convert law to law by, but she didn't name me. I wasn't happy.
No, I know. She could have gone a step further, but still, it's one of the things that's ingrained in your memory when you come to ABL. Anyway, and then the next thing we did was extend the second creditors meeting because, again, this is a company, and you guys, I don't know if you remember, but there was a series of, huge things were happening as well, and it was kind of, there was a series of quite severe windstorms that happened in South Australia. Arrium runs an enormous electrical blast furnace that has its own generator but is also tapped into the South Australian power grid. In the event that the power stops to that generator, the molten metal inside it hardens and the thing is useless, and it's about $100 million worth of equipment. And right in the middle of these sorts of things, we were trying, desperately to get work out what the plan was to restructure Arrium, to find a way to have it survive and thrive. There were these sorts of catastrophes happening at the same time.
Can I just talk about that too, to give you again the practical problems we were dealing with? Arrium was a basket case in terms of Whyalla. No one could see that Whyalla could survive, and without wishing to be too negative about it, I think it will be a challenging asset for a long time to come. But when the power grid came down and there was a chance that mill or furnace was going to go cold, my great apprehension, as was the administrators, was they were going to let it go cold. The government was not going to get power into Whyalla. They'd let it go cold and then say the whole plant had closed down, and that would be the quickest way politically to get rid of it. So we had to deal with the politics of it shutting down at that point in time. And again, even within the body of creditors, to some extent, Arrium was more valuable without Whyalla than with Whyalla. Whyalla is a drag on the value of the good businesses in Arrium, but there is a real dilemma, because you've got all your employees in the town, and you've got contractors in the town. So those creditors who are just money creditors and looking at maximising the return, they had a vested interest in it closing. Those who wanted to keep their jobs for the future had a vested interest in not closing. So these are kind of the real-time problems you're dealing with, as well as a massive media management issue, because everyone was saying it's going to go cold, and if it goes cold, it's all over.
Anyway, second creditors meeting has to happen within 25 days of the first creditors meeting, which in the circumstances of this collapse was again completely unfeasible, and so we extended that meeting too, using the magical provision. But the point being that there are a series of multiple court applications happening at this time. Leon did most of the advocacy for them, or I think all of the advocacy for them, before Justice Davies basically seeking to vary parts of the Act on, at this meeting you're meant to decide the company's future. At this stage we didn't even know that we knew who all of the creditors were. So the meeting had to be extended. But in the end, the solution that Leon and the others came up with was to proceed to what is known as a deed of company arrangement. And again, I don't know how many of you have done this, but these are a compromise basically that's entered into between the company and its creditors. We call them colloquially dockers. Leon call them dokers for the first few months.
Sydney people call them dockers. Melbourne call them dokers.
Dokers, and we're like, it's so stupidly posh. They're dockers clearly. But
can I just back up a bit? I just want you to get to understand a bit more about voluntary administration. So when a company goes into voluntary administration, the first phase is a moratorium. Everything freezes. The administrators take control of the company. The board sits off to the side, and it's a moratorium. That is, it's frozen. And you have a first creditors meeting, and the first creditors meeting, you can appoint a committee of creditors and you get a report about what's going to go on. But the first creditors meeting is by and large a procedural or administrative meeting, but it's the second creditors meeting that's fundamental. It's at the second creditors meeting that the creditors decide, by majority of creditors in number and value, the outcome of the company. And there are 3.5 outcomes at the second creditors meeting.
3.5?
3.5. Outcome number one is this. The company should be liquidated. So if the company is a complete basket case and can't be saved, put it into liquidation. That's a terminal process to kill it off. The Americans call it Chapter 7, kill it off.
And everything gets sold, all of the proceeds get put in a pot, and then they're distributed ratably, pari passu, amongst all of the creditors.
The second choice is to return the company into the hands of the directors. And many of you might say, well, why would you ever have that choice of just giving it back to the directors? And I'll tell you why. Sometimes in the heady negotiations I spoke about before, some particular creditor says, I will not provide an extension of the loan, or I demand my money, and the company becomes insolvent, tips into voluntary administration, and then a deal is done. The financier says, for example, well, we didn't know you were so serious. We'll provide you accommodation, let's find a solution, let's get it out. So option number 2 is return the company into the hands of the directors, and the creditors can decide that. And option number 3 is the docker. And now, again, Australia has its own name for it, but globally, if you ever practice globally or follow US law, it's the plan of reorganisation. The docker is an acronym for deed of company arrangement. And it can be a moratorium, it can be a compromise, it can be any type of deed, but it's the plan of reorganisation. They're the three primary outcomes of the second creditors meeting. And the reason why I say there's a half is because the second creditors meeting can also be adjourned for a period of time. I think up to 60 days, the creditors can adjourn the meeting. And so sometimes you come along to these meetings and you can adjourn it. Now, our legislation, I think, has a number of lacunas in it. One of them is the outcome of these meetings, because what can happen is someone can pitch a competitive offer during the course of that meeting and you can have pandemonium.
And you can see there are lots of recent restructuring, Channel 10 and things like that, where they've been competing proposals effectively of how we're going to restructure the company, what's it going to look like going forward, depending on who wants to take control or what their economic interests are.
Yeah, so they're difficult. The first creditors meeting, as I said, is not so important. Second's vitally important. And again, controlling the meetings with advocacy and strength is really critical. I think when ANZIT collapsed at the first creditors meeting, there were 5,000 unionists who blamed Air New Zealand, who owned ANZIT, for the failure of the ANZIT Airlines. And, you know, the first creditors meeting, you can establish a committee of creditors, and someone from Air New Zealand nominated for the committee of creditors. And there was such antipathy in the meeting room, 5,000 people screaming about it, and someone from Air New Zealand, who they blame for the failure, nominates for the committee. And I remember it broke into a chant of bastards, uncontrollable, bastards, just an uncontrollable chant across the room. And I was at that point advising Greg Combay, who was then the secretary of the ACTU, and I said, get up on the stage and welcome Air New Zealand on the committee. And he said, are you fucking with me? And I said, absolutely not. If we're going to save the airline, we have to work with everyone. Do it. And Greg got up, calmed everyone down and said, we have to work with everyone. We have to work with everyone. And Air New Zealand has an interest here, and we have to find a solution. Now, I'll tell you something. Within 24 hours of that event, Air New Zealand reached out to settle all of its disputes and paid about $200 million to ANZIT. That $200 million formed the base upon which the airline may have been saved. At the end of the day, it wasn't saved, but it was a demonstration of what you need to do and how quickly you need to move when these events arise. And to Combay's great credit, he championed a sea change by demonstrating that the union movement would be sensible and responsible in terms of corporate collapse. The following day, he received a massive write-up in the Murdoch media about what a phenomenal step it was that he'd moved to save an airline, because up until that point in time, the union movement had waged industrial relations war when there was a corporate collapse. And in fact, that was what everyone expected when ANZIT collapsed. And for those of you who don't know, it collapsed a day after 9/11. And so it was a very strange time in Australia, and this was seen as a very important move for him to be exercising rights as creditors. So again, these meetings, you have to be on your toes, and as advocates, you have to be able to deal with things that will come from the floor and deal with them quickly. And it's a great opportunity for lawyers and the advisors to work together to generate very good outcomes. And I should just say that it's a perfect demonstration of bringing together different interests into an aligned form.
So with the Arrium dockers, I mean, the idea of a docker is basically the content is flexible. It's not prescribed in the Act. If you look at those sections, you'll see that they don't actually say what type of restructuring you have to do. Not what the new entity needs to look at, none of that. They basically give you, you're permitted to, for example, discriminate between different types of creditors, but there is one test that is in the Act, that the creditors should be no worse off under a docker than they would be under any liquidation. The difficulty here, again, with this huge behemoth that the administrators were dealing with, is that they had determined the best thing to do was to try and sell it as a going concern, as an operating entity, and sell it in one line, and that required a long period of time to be able to do that. So they went to the second meeting of creditors without actually a transaction to propose. They didn't have any buyers at that stage. They had, nobody. And the dockers, or the dokers, that we came up with were basically dokers that permitted whatever the ultimate transaction was to occur with necessary limitations and restrictions and ability for creditors to be consulted. But they were a different structure of DOCA that had not previously been used in Australia. There were two or three I suppose, interesting features of them. The first was that we were aggregating, so there are provisions again in the Corporations Act that deal with pooling of corporate groups. You can see a lot of corporate groups, you can understand that you could have a pooling mechanism, but the pooling mechanism is intensely complex and unwieldy and expensive and doesn't work particularly in this type of... Have you done one?
I've done them. I argued before the Justice Davies that to allow us to do this in a way that didn't conform with anything that had ever been done before. And I was opposed in that application by a silk retained by the regulator who did not, ASIC, they did not wish this to go ahead. And the truth is, I advocate differently in that jurisdiction to other jurisdictions. So, as you know, most advocacy is black letter law based. That is, you go and present a series of structured black letter law arguments to a court and argue why your case should be determined in accordance with the black letter of the law.
In accordance with precedent. So this has been done before, and this way the court's been empowered to make these particular types of orders.
Many of these applications are novel. They've never been done before, and the way I advocate in those courts is quite different. First of all, I'm a solicitor advocate. I don't brief out. The reason I don't brief out is they're complicated factually, and the judges know that the lawyers who are working on the transaction know the transaction better than anyone. And so they will accept submissions from someone like me or Susanna or any of you if you practice in this area.
More likely to accept
without a problem. And so one of the things I did do in the advocacy was to demonstrate the problem of Arrium. That is, I told the judge of all of the problems with Arrium, all of the problems, all the stakeholders, all the people adversely affected by it, and then said, and here, Your Honour, is the black letter law solution. Okay, that's it. And whilst I walked the judge through the evidence, I was really making the submission as we went. What Mr. Corder is really saying there is the Prime Minister himself has now intervened and says we have to do something to be a disaster, and the Premier's intervened and the opposition. And so what you really do is, I know this is being filmed, I'm uncomfortable about it, you shame the court into fixing it and to avoid the collapse. You shame the court. And you've got all the media there, and so there's an enormous amount of pressure on the judge.
And at the same time, you have the regulator, and they have a different interest. Their interest is to make sure that they are keeping to black letter solutions and not having too many novel things happen because...
So I was going to talk about the regulator. They were really difficult. Yeah. So they said, the Act says that when you go to the second creditors meeting, creditors must vote with a comparator. What will they get under the DOCA, the plan, versus what will they get in liquidation?
Because you've got to determine that you're agreeing to something that would put you in no worse position than you would be in a winding up of each entity. And so the idea usually is you go with a transaction, you say this is how many cents you'll get in the dollar under this, and we've quantified that if we were to sell everything in a wind up, you'd get less, and therefore you should vote for this proposal. So it's usually binary, and they expect transactions to be quantified in a way that makes that choice easy for creditors. But here we didn't have a transaction.
We had no transaction, we had no comparator, and the regulator said this has never been done before, and the Act is clear, it says you've got to do it. And then you had the professional handbook which governs the conduct of administrators, which says exactly the same. It is misconduct by an administrator to go to a creditors meeting and to put such an arrangement up. And what I did was really to convince the court that in these remarkable circumstances there was no choice. We couldn't sell the assets if we couldn't consolidate. And the reason I was a bit jumpy when Susanna used the word pooling is this. I steadfastly rejected the use of the word pooling. I was never going to use the word pooling.
That's what I was saying. We didn't
pool. Advocacy, because God forbid the judge would have made me pool, because then the judge would have wanted to know how it all looked and how it all would have worked through the 94 companies, and we didn't have time to do that work.
Pooling, you've got to show for each one of them that basically...
Now, I know that I'm focusing a lot on the practical ways of dealing with this area, but in truth, I was very much educated by attending a lecture in America by a US bankruptcy judge who talked about substantive consolidation a few months earlier. And he talked about how the US dealt with it. How would the US deal with this kind of problem?
Leon came back from this conference. He's like, look up some standard consolidation. I want you to go and find every single article on this. I'm like, there's not a lot there. You know, I couldn't find anything.
Bring American law to Australia under 447A. That was my thinking. In fact, I wrote to the judge. I wrote to him. I said, look.
And then he told him what we did, and he's like, you did that?
No, there was another judge. So I asked him for his papers and notes. He had no papers and notes, and he said, you're kidding. I said, no, this is really valuable to me. Anyway, we did it. Subsequently, I appeared in a panel in London with Judge Peck, who did the global Lehman collapse. And I appeared with a French counsel, an English senior counsel, and we were debating. It was like a war of jurisdictions. Who had the best jurisdiction?
Lessons from the colonies. Here.
And I talked about what we did on Arrium with the consolidation, and Judge Peck went absolutely nuts about it. He said, I can't believe you did that, because we've not gone that far in the US. But we did it. We took the law in Australia to a position that even the US haven't quite got to. He was a little upset that they hadn't done it before us.
So what we had was 93 transaction support dockers, as they were known, which basically operated. They gave the administrators godlike powers, as we describe them. They basically permitted them to novate debt. So you're a supplier, you supply electricity to the company that runs the Whyalla furnace. We say, okay, your liability is going to end up being a liability of the parent entity. We aggregated all of the liabilities and the assets basically into one entity, which was known as the ACDC. There were some old rockers at Cordermentha who liked the Akadaka name, so that was the head entity into which we aggregated all of the liabilities and assets of the group. And we've ended up with basically liabilities being novated, so you ended up with clean shells that were able to be sold. When you're buying a company, you don't want to buy long-tail environmental liabilities. You don't want to buy a whole heap of debt that is in that company. Please.
Well, which company was that aggregated into?
I think, and I should remember, but I think it was the head co initially, and it's become, it's not even known as Akadaka anymore. It's now known by its ACN. But it was Headco that it went into.
Just on that, isn't there a danger with that? Like much like what James Hardy did, they put all of their liability into a different company and then just
Absolutely, and Leon has a story to tell about that as well.
Can I just say this? I won't take you on about James Hardy, having spent a year of my life unravelling James Hardy for James Hardy. Let me qualify that by saying that Combay was my opponent, and the only reason I acted for James Hardy was after the Ansett experience. He said I would be a trusted opponent, and we fixed it together. But the thing about James Hardy was this. The subsidiary entities, Amica and Amaba, which had the liabilities for the asbestos production, were actually ring-fenced from the parent. And so the parent was not exposed. And so many people assumed that there was some clever device to create that. It was set up that way from the beginning. The conduct that they engaged in trying to make it stronger was so colourable that everyone just assumed they must have been liable at the headstock entity when they weren't.
But you're right, there's a degree of creditor nervousness when you say to a creditor, well, we're novating your debt from this entity to this entity, and at the same time we're telling them, I'm going to put all of the proceeds of the assets into that entity. There was a legal machinery that was set up in this to make sure that creditors, when they were voting, had a degree of certainty that they weren't going to end up with a liability to an entity that had none of the proceeds funneling through to it. And it's difficult because these are entities in voluntary administration, so there are administrators there, but you could see a circumstance where you could lose control of a subsidiary with assets in it that was being sold via a liquidation. If you had someone greenmailing, for example, might be able to take control of that entity, seize those assets and prevent them from being funneled back into an aggregated structure. So there was certainly a degree of creditor nervousness about what was being proposed.
The judge asked the same question in the hearing, and we satisfied the judge by explaining that there was a mechanism throughout the entities for a true-up. And that was what Judge Peck in America was screaming about. He was saying that under American law you would have to work out who was better off and who was worse off before you could aggregate. In Australia we did the aggregation without doing it, with a promise to fix it at the back end, not the front end.
Yeah. So there was a mechanism that if you felt that you had been prejudiced by this, there was a mechanism of determining. But Leon also said you had to take into account in that true-up the costs and expenses of individual entity liquidations. And like I said, every time we sent notices out, it was $500,000 just to do the posting. It's a huge expense to have individual entity liquidations in these circumstances. So that was part of the factor that had to be taken into account. Anyway, things ended happily. So this is the keys of Whyalla being given to Mr Gupta, who was the head of the GFG Alliance, which was a UK entity after about 9 months of the administrators running this huge entity with 10,000 employees and blast furnaces, with the power turned off and environmental liabilities. A sale process was conducted. It ended with a successful sale. Molycop was sold for 1.3 billion. Arrium was sold for about 700 million via a share sale of clean entities. So the shares in subsidiaries in Arrium that conducted the operating businesses were sold, liabilities having been novated back to the Akadaka company, and the assets, the proceeds of that asset sale have gone back to the Akadaka company for distribution to the creditors of the group. So it was actually, it was a great result in the end, and we'll see how Whyalla travels in the future. I mean, they're still working. I understand there's some.
I wouldn't go there.
In any event, so that was the end result of the sale process. I don't know. I think you have done. This is 16 months, I think it was, from where to go in relation to sale. What's happening now in relation to Arrium is that the administrators are also conducting their statutory investigations. So administrators have obligations to investigate the reasons for the collapse and look at possible returns. Are there claims that the companies themselves can bring, and are there claims against directors? And so there are director, it's 588G, that area of the Corporations Act. There are claims that can be brought against directors in relation to insolvent trading or other voidable transactions. And there's been, I think, 35 days of examinations where the directors of the Arrium Group and some of their advisors, their lawyers and their merchant bankers have been examined publicly in court to determine what are the reasons for the collapse. So it's kind of a watch this space to see whether there are any actual court proceedings brought. Also open to the regulator to bring proceedings, including for breaches of directors' duties if they feel there have been any in the process. It's a breach of a director's duties to continue trading if the company is insolvent, so that's going to be a live question. And there are also claims that are open to creditors even after they receive their pari passu cents in the dollar from the proceeds of the sale. There are potential claims for misleading and deceptive conduct against directors. You could envisage that if you were a lender who was lending into this group at the time, you're being told things about solvency that turned out to be not true, you might have claims there. So there's, this is, as with any of these great collapses, there's a lot of law to come, LORE as well as LAW, no doubt. But so watch this space. And
can I just, I know the hour is done and we'll wind up, but I just want to give you a perspective from our younger lawyers. On matters like this, they're massively complicated and difficult, and we try to give our younger lawyers as much exposure to these issues as we can. We depend very heavily upon the research skills that younger lawyers bring to the table, whether it's on directors' duties, whether it's upon substantive consolidation, whether it's upon pooling or the history of provisions. And that's a really important part of our process. We work with our younger lawyers on these things. We expect our younger lawyers to play their role in it and to participate in it.
We took one of our younger lawyers in Sydney and made him the General Counsel of Arrium. He's just been appointed a partner, so that's coming up. But,
I think that one of our younger lawyers who worked on these things once, he was sitting in his room. I said, "What are you doing now?" And he said, "Oh, not a lot." And I said, "Good, come with me. You'll be on the front page of tomorrow's newspaper." And he thought I was kidding. His nickname is now Hollywood
because the photo is him pushing Leon out of the way.
So if ever you come to ABL, ask for Hollywood.
Well, Mr. Hollywood is...
The one thing I learned about that matter was never get between Hollywood and a camera. It's a fascinating area of law with such breadth and interest. And that's why I did react to the reference to corporate mortality, because someone like me thinks it's the anathema of what we ought to be doing when there is corporate failure. Corporate failure is part of the economic process. That is risk-taking, entrepreneurship. There is going to be failure. And what we have to do is manage that failure in the most efficient way to minimise the impact.
And fair. And also consider, when you look at things like Whyalla, there is a cost to the other creditors that was taken into account in the decisions that the whole creditor body made about that.
So my goal in coming here today is to encourage all of you to become insolvency and restructuring lawyers in the future, even those who I know have no real interest in that area at all.
It's not all about the first creditors meeting. Has anyone got any questions?
So when you're dealing with cases like this, which are so complex and so convoluted, and you have so many competing interests and so many different parties, whether that be, actual legal consequences or personal consequences, like that example you gave with people actually committing suicide because of this, what measures are in place for you guys when you're actually dealing with this to not actually lose track of how much is going on and what's happening? Like, how do you actually stay focused on actually coming to a viable legal solution?
I cleared my decks, so when this came up, that basically became all I did for 6 months. I mean, it was incredibly complicated, and the thing I was amazed, we were guided at the very beginning. We had Quarter Mentha working with us, who were incredibly experienced insolvency practitioners. But I remember going to the first meeting, which was the day after they had been in place, and already they had found a way of explaining complexity that was, it took me probably a week to get it, but it was starting to make sense, trying to track through all of the very, these people owned, employed by this company, do these things here, where the proceeds end up in this company here. I mean, it was the business units not matching up with,
Can I just answer it this way? This is project management. It's project management. So the way it works generally for these big corporate collapses, the senior partners of the insolvency firm and the senior partners of our firm will work together. In fact, I think when ANZIT collapsed, I moved out of ABL for 6 months or a year. And in fact, I was referred to often as the third administrator. And that's because on one occasion, Quarter was in the witness box being asked what to do on some problem, which was very complicated legally. And he just turned around and he said that he was being cross-examined by Peter Wood, actually, one of Susanna's friends, who's a senior counsel. And he was being twisted into a knot. And eventually he said to the judge, he said, look, I don't know. I'd ring up Leon, I'd wander into his office and say, what are we going to do now?
Yeah.
And we would do it. And there's been some debate about whether or not lawyers should also be administrators, because some of these complex legal things require that skill. So you have that structure. Secondly, you have team meetings every single day. Quarter Mentha would do them twice a day, morning and night. We probably did them once a day in the morning. And with email and things are channelled up and then pushed down. And so people worked in teams. Susanna had a team, we got a litigation team, we had a property team, we had a tax team, we had a liability team, we had an asset team, we had a beatification team. We had all different teams working on different aspects, but by and large, someone like me had a broad idea of what everyone was doing. We made mistakes. I think we encumbered a secured asset very early on, trying to save the companies, which we had to unravel.
Very awkward,
and again, the best way to do it is when you pick up the mistake, don't cover it up, go to a judge and say, Your Honour, we made a mistake.
Yeah.
We didn't have time to work it out. And the courts are incredibly forgiving because they get what the substratum to your question, which is, how do you manage this pandemonium when it breaks?
Part 5.3, read it.
I was just curious about how, especially I guess from a legal, potentially also from a strategic perspective, but how, especially in these scenarios where the quantitative side can be obviously quite complex, is there ever a problem with sort of your level of expertise and what you're being experienced in developing your skills? Does that ever pose itself as a barrier, the amount of potential quantitative complexity that you engage with?
It sounds facile, but all lawyers should learn how to use Excel. It's one of the things, I did maths through high school, a 4-unit, whatever, I don't know, what do you have down here in Victoria, but I did a lot of mathematics but I did an arts degree at university. I don't necessarily know that you have to, be a quant, but you need to know how to manipulate those types of tools. And I make all of our younger lawyers go and study it because it really bugs me that I don't know the full potential of things like that. What do you reckon?
I don't.
Yeah.
Okay, so my job as an advocate is to fully understand things. If you notice, even from my presentation today, I try to be monosyllabic. That is, people who truly understand what they're doing will be able to, in monosyllabic terms, explain to a judge what it's all about. There are complexities. I had to deal with a beneficiation plant, which I won't go into. It's a very complicated plant to increase productivity of an iron mill or something, and I had to get a judge to make orders about it. We all called it the beatification plant, referring to Corda or Mintha trying to beatify themselves for saving Arrium's township of Whyalla. But you learn it, and you have to learn it well, and the people who instruct you are highly sophisticated professionals.
And again, you know, with all of the background that you would expect in accounting, all of that sort of stuff as well. So you're working with experts in the field, but you've got to know, they need to learn how to use Excel.
Okay, well, can I just say this? The thing that I love about corporate restructuring is no case is ever the same.
Yeah.
No case is ever the same. I could probably have spent 2 or 3 hours telling you about the unique and bespoke solutions to a number of corporate collapses or near corporate collapses. They're all different. But the great thing about the area is you're educated about all these things you know nothing about.
If no cases are ever the same, how often is it that the regulations are actually apt to cover what you're going to be doing in the restructuring?
Don't care. The answer is find the solution and then work out how to fix it.
Yeah.
All right? And so the regulations are hopeless. I mean, first of all, if you look at the definition of who is bound by a deed of company arrangement, you'll say it's those who, you know, obviously vote in favour of it, and it binds people in relation to their debts. But you can't bind secured creditors or property creditors, people who own property. If you look at the definition of debt, it picks up property. So that there are a whole lot of lacunas everywhere. They're just a whole series of problems with the regulations. They'll tidy them up, but I think 447A is the solution. I should say this, that provision was included because of the work of a committee called the Harmer Committee. And I remember giving a speech once about the breadth of it with one of the guys, a guy called Richard Fisher, who was on the Harmer Committee. They never intended Part 5.3A to be so judge-driven. They never intended it that way. It was intended to be, one size fits all and just cookie cutter stuff and go through the
Quickly
regs.
come in, come up with a transaction,
Correct.
put the proposal, vote in 25 days, and off you go.
And I was actually speaking on a different topic after him, and he described that what we had done to 447A was breathtaking, and I didn't regard it as a compliment.
Didn't he say it was vandalism or?
Vandalism and breathtaking. But just so you know that the juridical basis for what we did began with Ken Hayne in the Victorian Supreme Court on Brashes, first public company collapse. And Ken Hayne dealt with it in a very black letter law way, and he set the tone for what we wanted to do, and I unashamedly mirrored US bankruptcy stuff. And we've helped forge an area of law.